Today, I will present to you two issues in assignment 2, which is the first issue is whether at the time Sultana's president had breached the Geneva Convention signed by the three states parties due to his alleged wrongdoings.
Articles 49, 50, 129 and 146 of the Geneva Conventions. In these articles, it has been stated that the states are required to look for alleged offenders regardless to their powers and positions. This has been reflected through the equation aut dedere aut judicare, where the state must choose option to prosecute or extradite individuals as liable who have purportedly committed grave breaches no matter who the person is. This obligation forces an active duty on states since they need to guarantee that individual liable to be arrested and prosecuted regardless of sovereign immunity. The prima facie case to be referred for the legal provision is Al-Oda vs. US. The judge in this case has stated that Guantanamo Detainees Treaty and international law claims are barred by sovereign immunity. It does not apply because doctrine bars on the offensive claims against the agents and federal government. Sovereign immunity has never barred habeas corpus actions against the federal officers.
By applying to this case, Abraham Tona is the president of Satonia commit a war crime. Currently, he is on another state which is Colosia. Based on Article 49, 15, 129 and 146 of Geneva Convention, the Colosia authorities can arrest him as the criminal even though of his special position as the Satonia president. Pursuant to the case of Al-Oda versus United States 2002, sovereign immunity for Abraham Tona cannot be applied, although in the previous practice, the president has immunity in action for damages for all the acts. The Geneva Convention specifies all the state members to try to accuse criminal regardless for their special position are, and either put them under the relentless scrutiny for their own courts or turn them over to a jury on another state.
So, in conclusion, Abraham Tona, Sultana's president, had breached the Geneva Convention due to his alleged wrongdoings, as his position as the president does not adequately protect him from judicial direction.
And the second issue in this assignment, we found that whether the state party, which is Colosia, has a jurisdiction to indict the Sultana's president for his alleged wrongdoing.
For the legal aspect, we have referred to the 4th Geneva Convention 1949. We refer to Article 2, whereby it explains on the scope of signatories and how they are bound by the said convention. Article 3 is on the scope of persons that are relevant to the said convention, and Article 4 is on the scope of protected person. And furthermore, we have referred to the case of Democratic Republic of Congo against Belgium in the year 2002, and also we have referred to the principle of universal jurisdiction. Moving on to the application of the said league.
In current situation, Sultana military forces attacked Minoria and the three Minorians had fled from the country. After the news of President visiting Colossian was known to them, they entered the Colossian police station and provided information indicating that the president had committed crimes which amounting to the breaches of Geneva Convention and requested the Colossian authorities to take necessary action to bring the president to justice. Colosia had adopted penal provision covering that the types of the act that the president allegedly had committed. According to universality principle, the state will apprehend the perpetrator regardless of the place an offence had been committed, and the nationality of the perpetrator may persecute and punish that person on behalf of the whole community so that the perpetrator will not escape without punishment. Thus, Colosia has the jurisdiction to apprehend the president and bring necessary action to bring justice for Minoria and the Minorian.
In conclusion, Colosia has jurisdiction to indict President Abraham Tona for his alleged wrongdoing, as all stated have presumed that the principle of universal jurisdiction by which an offence was committed irrespective of the place and nationality of the perpetrator or the victim was justified.